How do you lose 100% of your retirement assets in divorce, even after community property has already been divided? In the Benedetti case, wife secured a $2 million judgment for husband's breach of fiduciary duty after he squandered $3.6 million in cash that even forensic accountants couldn't find. Next, wife's lawyers filed a radical request for order in the trial court and on appeal, seeking 100% of husband's 4 Major League Baseball retirement accounts, not as division of marital property or modification, but as a state statutory reimbursement of squandered marital millions, creating a marital property right enforceable through QDRO. In episode 106, Major League QDRO, part 2 of 2, we explore the legal strategy and appellate court analysis potentially transferring a QDRO grand slam. That is 100% of 4 Major League Baseball retirement accounts to one spouse, even after the original QDROs split them 50-50, and even though one was separate property.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lease Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lease Murray.
I'm Kelly Lease Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We don't just tell you what actually happened in court. We also show you why it matters to your professional practice and how it impacts your client's wealth outcomes. Let's gavel in. In episode 106, Major League QDRO, we examine how a Major League Baseball all-star risked losing 100% of all of his retirement accounts to his former wife's $2 million judgment for breach of fiduciary duty. As a recap, in episode 105, we addressed the first of 2 appeals in the Benedetti case. The first appeal concerned the divorce judgment itself and the award of $2 million to the wife for the husband's breach of fiduciary duty. That $2 million judgment was affirmed in the first appeal. But that didn't decide how the wife collected the judgment. That was addressed in the second appeal, which we're covering here in episode 106. Keep in mind that the $2 million judgment was $1.8 million in squandered assets, restoring to the wife her 50% share of $3.6 million in cash that the husband admitted at his deposition he could not account for. Even forensic accountants couldn't find it. The other $200,000, it was actually $230,000, that was legal fees for the wife and also a mandatory sanction for breach of fiduciary duty. Critical to the appeal and the result are 4 Major League Baseball retirement accounts. The first 3 were marital assets. They originated during the marriage, but the fourth was created 2 years after separation when the husband was reemployed in the Major League Baseball coaching system. At risk in the second appeal, 100% of all 4 of those retirement accounts. 3 were marital, 1 was separate property. The first 3 had already been divided 50-50 as part of the divorce itself. In the second appeal, the husband had 4 main arguments. The first argued for a narrow interpretation of the QDRO, that it was inapplicable to this $2 million judgment. Because the $2 million was not a provision of marital rights, the husband argued, that QDRO is limited to the division of the community asset in those retirement assets, and that those assets, the first 3 retirement accounts, had already been divided 50-50. And the husband also argued that QDRO, a qualified domestic relations order, isn't available to enforce damages for breach of fiduciary duty. Second, the husband argued that what the wife was seeking, her request for order to be awarded 100% of all 4 retirement accounts, violated California statutes Third, that the amended QDRO disregarded ERISA's purpose, and the primary purpose, like those California state statutes, is protecting retirement income for both spouses. The fourth argument failed straight away. In the fourth argument on appeal, the husband and his lawyers argued that the 4 retirement accounts were never valued, that when the trial court awarded 100% of the 4 retirement accounts, 3 marital and 1 separate, there was insufficient evidence in the record, not substantial evidence, and therefore the trial court erred. The California Court of Appeals rejected this argument because it was waived. The failure to value the retirement accounts was never raised by the husband at the trial level. Generally, when an argument is not raised at the trial level, it cannot be raised for the first time on appeal. It's deemed waived for the appellate purposes. Here, it's rather shocking that the husband's trial counsel did not quantify these 4 accounts. What if the 4 of them added up to more than $2 million? That seems like it would be unfair, and that was what the husband and his appellate counsel tried to argue during the second appeal. But the wife and her lawyers on appeal argued that the 4 retirement accounts did not even equal $2 million. They were less than $2 million, so they wouldn't even satisfy the entire judgment that was owed. The husband lost on appeal concerning an additional argument that the $2 million damages for breach of fiduciary duty, mandatory penalty, and also legal fees that were awarded to the wife in total $2 million, that none of it related to the retirement assets themselves. That argument was imprecise, inaccurate, and rejected by the California Court of Appeals straight away because factually the husband prematurely cashed out an IRA and 401k, resulting in thousands of dollars in taxes and penalties. That means at least some of the $2 million, at least some of the $3.6 million squandered included thousands of dollars in taxes and penalties from prematurely cashed out retirement assets. The appellate court also quoted the trial court, confirming that at the time of the divorce, the wife's retirement assets were nil. In episode 105, we covered this detailed timeline of events. Here in episode 106, for purposes of the second separate appeal regarding who is awarded the remaining portions of the retirement accounts, we're going to be looking at the dates relevant to various QDRO orders that were signed by the trial court before any of these appeals happened. The first QDRO was actually signed in December of 2018, and it divided one of the 3 marital retirement accounts 50-50. Then in January 2019, this divorce was actually bifurcated. January 2019, the trial court signed a status-only order dissolving the marriage, but none of the financial issues had been resolved. And in California, that is not uncommon to bifurcate the proceedings, granting the divorce or the marriage dissolution and reserving for later the financial issues, particularly when they're complicated, as was the case in the Benedetti divorce. In April 2019, the second QDRO was signed. It's another Major League Baseball retirement account. It was marital. It was divided 50-50. Then 3 years later, in May of 2022, there was a 7-day divorce trial regarding the finances and the breach of fiduciary duty. In December 2022, the final judgment of divorce and financial divorce was signed by the trial court. The wife was awarded $2 million for her husband's breach of fiduciary duty. Reminder, the divorce trial court confirmed that $3.6 million was squandered. That's 49% of the husband's after-tax earnings as a Major League Baseball player over an 8-year career. The husband grossed around $11 million. After taxes, his gross net was approximately $7 million. 49% of that, the husband couldn't account for. Financial professionals and forensic accountants couldn't find it. So $3.6 million was squandered. Half of that is $1.8 million. The wife was awarded the restoration of her community share in $1.8 million plus approximately $230,000 in other penalties and legal fees. But in April of 2023, the trial court grants the wife's new request for order and awards all 4 Major League Baseball retirement accounts to the wife, 100% of all of the retirement accounts. Quick recap. At this point, 3 of them have already been divided 50-50. So what the trial court is doing is taking from the husband his 50% remaining share in his retirement assets and awarding them to the wife. And then the fourth retirement account, another Major League Baseball retirement account, that originated 2 years after they were separated. It is not marital. Everyone agrees it's not marital. It is separate property. And in April of 2023, the trial court awards that separate property retirement account, 100% of it, to the wife. In 2024, on appeal number 1, the wife prevails. The California Court of Appeals affirms the $1.8 million plus $230,000 in legal fees and penalties to the wife for the husband's breach of fiduciary duty. After that appeal, the husband owes the wife $2 million. But that still left the second appeal, what we're addressing here in episode 106, the appeal regarding awarding 100% of all retirement assets to the wife as payment for the $2 million judgment for husband's breach of fiduciary duty. This was resolved in 2025, and in October of 2025, the California Supreme Court weighed in on whether it would take up the result. ERISA includes an exception to its anti-alienation provision. That exception is QDRO, a Qualified Domestic Relations Order. Under QDRO, it's a legal mechanism to divide retirement benefits in divorce between the plan participant, here that's the husband as the Major League Baseball player, and his former wife, who is not a plan participant. The traditional use of QDRO, a Qualified Domestic Relations Order, is property division of marital interest in retirement. Accordingly, the alternate payee is usually the former spouse, and that is the case here in the D. Benedetti case. The issue for the second appeal in D. Benedetti is whether QDRO can be used to compensate a spouse for the other spouse's breach of fiduciary duty. Is it even possible to award 100% of retirement assets to only one spouse? And can it be done for breach of fiduciary duty? The wife's QDRO legal strategy begins in March of 2023. This is after the December 2022 financial divorce. So December of 2022, the trial court signs the dissolution of marriage, resolving all of the financial issues. Then in March of 2023, the wife and her lawyers file a request for order, requesting 4 QDROs, one each for all 4 of the Major League Baseball retirement accounts. 3 are marital, 1 is separate property. The first 3 had already been divided 50-50. The 4th is separate property the husband had 100% ownership of. This request for order is asking the trial court to award all of the remaining value to the former wife. In April of 2023, the trial court signs that order. Husband appeals the divorce judgment itself and the QDRO orders. One of the issues in this QDRO appeal is easily answered at the federal level. A QDRO may assign all or a portion of a retirement plan to an alternate payee. That means one spouse, including the non-participant spouse, may be awarded 100% of a retirement account. ERISA itself is not a barrier to that. So that's the first step that the wife needed to prevail on appeal. But the QDRO appeal for D. Benedetti really centers on what label is legally applied to that $2 million judgment. What is it legally? I mean, it's $2 million, but is it, as the husband argued in the lower right of this slide, is it redivision of an already divided marital property? Is it improper modification of marital property division? If it's either of those things, husband should win on appeal. Is it an equalizing payment? Is it simply paying the wife to equalize the division of marital assets? That may change whether a QDRO can be used for those purposes. Is it a judgment for damages? Now, the $2 million is a judgment, and it is indisputably a judgment for breach of fiduciary duties. But does that qualify as damages in the sense of a civil non-marital contract? That may make a difference. And then finally, in the upper left, is it the state statutory restoration or reimbursement of squandered community property? Reviewing the husband's 4 defenses, we already took care of the defense in the lower right. He waived it, the non-value of the 4 retirement accounts that was waived, and so it wasn't addressed on appeal. Sidebar, that is a bad thing to waive. And it brings up an important point about the difference between trial lawyers and appellate lawyers. For a high net worth divorce, it is really important to make sure you have your entire team in place, your legal professionals at the trial level, your financial professionals, including forensic accountants, your QDRO experts, because is the trial record going to support or the award of a QDRO or the defense of a QDRO? But here, appellate counsel should have been included at the trial level for husband and wife. And maybe the wife did include them, but the husband certainly didn't. This was a mistake at the trial level, waived a significant issue that appellate counsel could have shown to the trial lawyers. You're going to need on appeal to have valued the 4 retirement accounts in order to argue she's being awarded too much value for that $2 million judgment. The husband was arguing for a narrower application of QDRO, that the QDRO was inapplicable to the $2 million breach of fiduciary duty judgment. Number one, the husband argued it was not the provision of marital rights, that is narrowly construed. That QDRO is limited to the division of the community interest in retirement assets. Now, husband is arguing this. We're going to take a look at how the California Court of Appeals resolved those issues. The husband separately argued that California statutes echoing federal anti-alienation of retirement assets. The primary purpose of these is to protect retirement income for both spouses. Husband argued because of that purpose, those California statutes actually prevented awarding all 4 retirement accounts through 4 QDRO orders to the wife. If you look at the upper right on this slide, judgment damages, the appellate court emphasized something the husband and his lawyers conceded on appeal, that damages for breach of fiduciary duty are not a division of property. That's how the appellate court took care of this. It is instead what's on the upper left of this slide. So it's not traditional contract damages. It is a state statutory restoration of marital assets that the other spouse squandered. As far as an equalizing payment, it is described a few times in the California Court of Appeals opinion as an equalizing payment, but their primary holding is that is a state statutory restoration. Interestingly, another issue the husband and his trial counsel waived at the trial level is the $200,000 in legal fees and discovery penalties. The husband and his trial counsel didn't preserve the issue of whether that could be paid through a QDRO and retirement assets. And because it was not raised at the trial level, it was waived on appeal. And the Court of Appeals assumed without deciding that the total $2 million judgment was state statutory restoration for breach of fiduciary duty. When? This is such a critical issue and actually one of our longer sidebars. When should divorcing spouses and their lawyers negotiate and litigate QDRO? When judgments within an entire divorce be arranged? The best time is before the dissolution judgment. That is the best time. Even better than that is to attempt to settle it at mediation, because at mediation, the husband and the wife can agree on remedies that even the trial court can't provide. There may be a state statute allowing something or prohibiting something. So long as what the husband and wife agree to is not otherwise illegal, they can make arrangements, for example, awarding 100% of all retirement assets to one spouse as an offset, not even what's occurring in the Benedetti case. I'm raising this as a sidebar for all professionals involved, for the lawyers at the trial level, the financial professionals at the trial level, the QDRO experts consulted at the trial level. When should all of you be talking about using a QDRO for enforcement, using a QDRO to repay something from one spouse to the other before the trial court signs the dissolution of marriage? Because in a number of states, trying to use a QDRO after the divorce is over is what the husband in Benedetti was trying to argue. It is sometimes construed as redivision of marital assets, improper modification. You avoid all of those problems, all of that litigation and appellate litigation by resolving this before the trial court signs the dissolution order, when your clients have the ability to choose how to divide marital assets. In Benedetti, this all occurred after the divorce judgment. The divorce judgment was signed in December of 2022. The wife and her lawyers filed a request for order in March of 2023. And they had to go through a second separate appeal on the four QDRO orders, because all of this wasn't incorporated into the December 2022 financial dissolution of marriage. The trial court had the authority when dividing assets. So some or all of these arguments may have been circumvented, no appeal needed, if it had been analyzed, negotiated, or simply argued to the trial court and ordered before the dissolution of marriage. Which brings us to the Marshall case. This is a 1995 California Court of Appeals decision that the husband and his lawyers relied heavily on. The result in Marshall mirrors the result in other states that hold a QDRO cannot be used after divorce to enforce a judgment for the division of assets. It can't be used to redivide already divided retirement assets. And that is why the husband and his lawyer spent a significant portion of their appellate briefs on this case. The appellate court in Benedetti, regarding the QDRO, the second appellate court decision, confirmed some of the similarities and then looked at the differences before ruling whether the Marshall case prevented the wife's request for order, prevented the Benedetti former wife from receiving 100% of four QDROs to compensate her for the breach of fiduciary duty $2 million judgment. So what's going on in the Marshall case? In 1995, the wife lost her attempt to secure a post-divorce QDRO to repay her over $30,000 she had to pay to the IRS. This is the Marshall divorce. So they owe about $14,000 to the IRS. They divorce in 1988. They agree in 1988 to file jointly their taxes for 1987. The husband agrees to be responsible for the nearly $14,000 owed to the IRS. Years later, she finds out the husband not only did not pay the IRS, in ensuing years between 1988 to 1991, they now owe almost $14,000 for the original tax obligation, plus $21,000 in penalties and interest. So now it's over $30,000, and the IRS is going after the wife to collect it. As part of the divorce, the wife already had received her share through a QDRO order of the husband's airline retirement account. With this post-divorce action, the wife was trying to get an additional QDRO to get money out of what remained from his interest in his airline retirement account to reimburse her for $30,000. That was denied at the trial level, and it was denied again on appeal. And here's why. In Marshall, this IRS debt did not relate to the provision of marital property rights. The court points out it was a debt owed to a third party, not even to a spouse, and the retirement account had previously been confirmed as the husband's separate property, and the wife cannot get an post-divorce QDRO from his retirement account to reimburse herself, and he's otherwise judgment proof. Judgment proof doesn't mean you can't get a judgment. Judgment proof means you can't collect it. So the only valuable asset that the husband had by 1991 was his otherwise protected retirement accounts. Now, how is this similar? How is Marshall similar to the husband's argument in Benedetti? First, the wife in Benedetti had already received 50% of 3 Major League Baseball accounts. That is very similar to Marshall. The wife in Benedetti was not seeking support. Same with Marshall. In Marshall, she's seeking reimbursement of what she had already paid to the IRS, and that it was not necessary to her for her financial support. In the Benedetti second appeal about the QDRO orders, the wife was not seeking the $2 million for her financial security or support. It was restoration of squandered assets for husband's breach of fiduciary duty. In Benedetti, like in Marshall, the wife was seeking to garnish the husband's remaining interest in Major League Baseball retirement accounts that everyone agreed were at that point the husband's separate property. The fourth alleged similarity was rejected in Benedetti, the second appeal. This is where the husband in Benedetti argued that the wife, as a non-retirement related creditor, that there was no remaining community property rights in his separate property, 50% of 3 Major League Baseball retirement accounts and 100% of the fourth that was created 2 years after separation. That was rejected by the California Court of Appeals in the QDRO 2025 decision in Benedetti. And here's why. In Marshall, the wife lost because what she was seeking, The QDRO 4, enforcement of a hold harmless provision for the husband to repay her $30,000 she paid to the IRS, was not a marital property right. She was a creditor. By contrast, in Benedetti, the second appeal regarding the 4 QDROs awarding the wife 100% of all remaining retirement assets, the appellate court relied on California statute section 1101G regarding breach of fiduciary duty and a reimbursement, and held that reimbursement, that restoration, is a marital property right, which supported a QDRO. Back to when the wife in Benedetti succeeded, mainly because of the type of debt. There is no guarantee that any other type of debt will be as successful with a post-divorce QDRO, let alone securing 100% of the former husband's interest in all of his retirement accounts. Under California Family Code 1101G, the California Court of Appeals held that the $2 million judgment for breach of fiduciary duty was a marital property right. Quote, the $2 million allowing wife to recover her 1101G reimbursement against husband's retirement accounts. And separately, that these 4 QDROs related to the provision of marital property rights and therefore qualified as QDROs even through separate property. After the intermediate appellate decision in Benedetti, appeal number 2 concerning the QDROs, many lawyers who wrote articles and blog posts about this case suggested we need to watch this space to see what the California Supreme Court does with it. Well, in October of 2025, the California Supreme Court denied review. Because the California Supreme Court denied review, that case is final, and we aren't receiving any further clarification of just how far QDROs reach for enforcement of post-divorce judgments concerning the type of debt or even access to separate property. All we know from Benedetti is that money owed because of breach of fiduciary duty can be compensated through QDROs that even reach separate property. What are the wealth protection lessons of Benedetti 1 and 2? The first takeaway is absence, the complete absence of accounting assistance, wealth management assistance, financial planning assistance, estate planning assistance. All of that was missing. The husband had complete control, and we know from the holdings in this case was held to have dissipated $6.6 million cash, gone. Forensic accountants couldn't find it. But hypothetically, what if this family, this high net worth earning family during the 8 years of the husband's Major League Baseball career, what if they had accounting advice, wealth management assistance, estate planning assistance? That would have benefited the whole family. Other key takeaways: what would be the net of paying for these services that were absent here? It certainly wouldn't equal $3.6 million, and many of those services would help that wealth grow. Separately, breach of fiduciary duty is a community property issue specific to California statutes. Other community property states may have something similar, but you need to check with legal counsel in your jurisdiction to make sure. Separate from that, though, is the concept of dissipating assets, and it is very similar to the results, the consequences of breach of fiduciary duty, but it may not work the same way regarding using a post-divorce QDRO. In the Benedetti case, this is a breach of fiduciary duty judgment based on community property and California statutes. Other community property states may have similar statutes, but you need to check with local counsel in your jurisdiction. For equitable distribution states, which is the majority of states, dissipating assets consequences is similar to breach of fiduciary duty, but in your state, unless there's a statute, it may not work with QDRO the way the wife succeeded here in Benedetti. Forensic accounting. Well, that speaks for itself. In the Benedetti case, the $3.6 million squandered, the forensic accountants couldn't find. Deterrence. Does this case really deter clients? Only if you help spread the word. The deterrence of this case is limited to the participants in this case. Most folks will never hear about Benedetti, will not learn these lessons. This is a cautionary tale that can be instructive for clients to actually show them just how important it is for their legal counsel to confer with their financial representation, their wealth managers. If it's a marriage dissolution proceeding, to do all of this before mediation, to do all of this before obviously the divorce trial, and to coordinate among all of the legal and financial professionals needed. Ultimately, this cautionary tale is an information opportunity for you to use with clients as needed. The ultimate irony of this case: the husband was highly successful in Major League Baseball, 8-year career, $11 million in gross earnings, helped his team reach the World Series, Silver Slugger Award, All-Star. But personally, nearly every wrong financial decision possible was made. The result: the husband lost everything. At the time of the divorce, there was no cash left, few assets left, and no retirement accounts for the husband, because 100% of what remained went to the wife. The cascade from financial mismanagement to penalties, interest, evasion during the divorce regarding discovery, which created more penalties, resulted in a total loss for the husband. Recapping the legal lessons of Benedetti, which are closely linked to the wealth issues. First, what constitutes a marital property right enforceable through a QDRO? Well, the answer to that is state law. In California, breach of fiduciary duty is a marital property right. That's Benedetti, which is unlike the Marshall case, where a debt owed to a third party is not a marital property right and can't be paid through a post-divorce QDRO. Second, QDRO itself at the federal level permits alienation of 100% of a retirement plan to the alternate payee, to the other spouse. That's allowed. It's not required, but it's allowed. And the answer depends again on state law. Does your state allow it? Does your state require it? Or does your state prevent it? Third, the takeaways from California and other states about dissipation, the common consequences of asset dissipation, which is available in every state. Another takeaway, number 4, is timing. We had a sidebar about this, and I want to remind everyone that the timing matters. Sooner is better. Before mediation, husband and wife can negotiate how to pay one, how to offset one asset with another, how to offset equalization or any other exchange of assets and funds. They can negotiate that, and so long as it's not illegal, they can agree to it and it will be approved by the trial court. Or dealing with these issues early can help trial counsel raise these issues and preserve the record with the trial court, so that if the result isn't as desired or the other side appeals, you can have this reviewed on appeal, because a number of issues in Benedetti were waived at the trial level financially. Number 5, QDRO orders themselves. Get expert assistance. It's not just whether this is a marital property right. How the order is written will determine whether the plan approves the QDRO. So it's not just the divorce court, it's also the plan itself. Get professional assistance and get it soon, again, before mediation, before divorce trial, to preserve any issues if this case goes up on appeal. And then 6, we don't know number 6, because the California Supreme Court denied review. We don't know whether there was judicial overreach. The California Supreme Court's denial of review suggests there was not, but that may be limited to breach of fiduciary duty under California Family Code 1101G. It could be a very narrow confirmation of non-overreach, but we're using a QDRO or 100% of retirement assets for a separate divorce judgment, equalization, or other damages may not work. So those are some of the limits of future use of Benedetti. Thank you for joining us. Stay tuned for a preview of our next episode. What happens when an irrevocable family trust holds over $2 million of marital assets but excludes one spouse entirely in a divorce? The Utah Supreme Court faced that exact question in the Dahl case. Here's the $2 million problem. If the trust was truly irrevocable, wife couldn't withdraw any marital assets under Utah law. And once divorced, she'd no longer qualify as settler's wife under beneficiary definition, meaning she'd lose any claim to $2 million in previously marital assets. But buried in Section 5.5 of that trust agreement was one clause with potentially contradictory language that would take the Utah Supreme Court to unravel the impact on the trust and in the divorce. Episode 107, Divorce busting irrevocable trusts? We examine how one clause impacted the revocability of an irrevocable family trust, explore choice of law with other critical legal issues that put $2 million of marital assets on the line, and analyze the Utah Supreme Court reasoning in this high-stakes divorce. Join us to see how it litigated and subscribe so you don't miss an episode.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.